out in April on drug and alcohol-free schools and testing programs. So we'll just advance here. I am the General Counsel of the North Dakota School Boards Association. I saw some familiar names on our list. Some of you work with me. Many of you may have seen me at our NDSBA conferences, or maybe you have called and reached out. I specialize in education law and employment law and a whole variety of practice areas. And I'm just coming up on my 2-year anniversary at the NDSBA. And have brought a lot of my past private practice experience to the role and have been implementing that in some of our newest policy updates. Specifically this last quarter, when we worked on policy updates, I really dove into the drug and alcohol policies based on my practice experience and expertise in some of these federal law areas. So I'm going to talk about the federal law requirements just generally that have always supported these required policies that the NDSBA has in place and available as templates. The two that I dove into this last quarter were policy DEAA, which is the drug and alcohol-free workplace policy, and then policy DBBA, which is the drug and alcohol testing programs for employees. So I'm just going to, it might not take the full hour, but I'm just going to walk through what revisions I made and the reasoning behind that and what the federal law says and why I made the recommendations that I did. And then I'll walk through some of actually just the actual track changes for these policies and show you why some language is required, why some language is optional, etc. So the federal law requirements, primarily, there's 2 primary federal laws that drive school policy in this area and require schools that are in receipt of federal funding to maintain a drug and alcohol-free workplace and learning environment and adopt and enforce policies against unlawful possession, use, or distribution of illicit drugs and alcohol on school property or during school activities. And those 2 primary laws that support the policy are most typically referred to as the Drug-Free Workplace Act and the Drug-Free Schools and Communities Act. So those are the 2 laws that I always cross-reference when I'm giving legal counsel in these areas, and the 2 laws that I made sure had all of the compliance checkpoints in the policy templates that are offered. The Drug-Free Workplace Act requires schools to adopt and implement a drug-free workplace program. And by program, that means clear policies, education, clear channels for reporting suspected substance abuse, clear enforcement procedures and disciplinary consequences, support and prevention resources, including employee assistance programs, and a drug testing program. The Drug-Free Schools and Communities Act requires schools to adopt similarly and implement a drug and alcohol abuse prevention program, except that they use the formal term drug and alcohol abuse prevention program. So sometimes if you're doing trainings or getting education in these areas as administrators and board members, you might see this program referred to as DAAP or DAP. And that program, very similar with the Drug-Free Workplace Act, except that it specifically incorporates requirements for schools, whereas the Drug-Free Workplace Act is going to apply to any recipients of federal funds, federal contractors, widely beyond schools. The Drug-Free Schools and Communities Act, of course, is specific to schools, but the overlap is pretty significant. So if you comply with one, you likely comply with the other. But DAP programs require schools to prohibit unlawful possession, use, or distribution by students and employees. That's why we have policies for both, on school property and school activities. The schools have to have sanctions for violations, including discipline up to expulsion or termination. There has to be education on health risks and a notification of the program and basically your policy, and making sure everyone is aware of the rules, the consequences, available resources. And then there has to be at least a biannual review of the drug and alcohol abuse prevention program. There's another federal law that I'll mention now, but is actually specific to the drug testing programs, alcohol and drug testing programs, and that's the Omnibus Transportation Employee Testing Act. So that's the law that I have to cross-reference along with the Drug-Free Workplace Act when I'm working on testing programs and providing counsel on testing that happens with employees in schools. It is no surprise, I'm sure, to any of you on the webinar that it is mandatory drug and alcohol testing for safety sensitive positions, primarily school bus drivers, which is a requirement if they have a commercial driver's license, a CDL. These requirements under that federal law require mandatory testing windows for pre-employment, random testing, reasonable suspicion, post-accident, and then return to duty. Pre-employment, the full queries and annual limited queries that are already available through the Federal Registry and the CDL Drug and Alcohol Clearinghouse, which whomever is in charge of onboarding in your school district is probably very familiar with that onboarding process and those pre-employment inquiries and checks that have to be done for your bus drivers. And then that law requires policy adoption, implementation, and distribution in compliance with the Department of Transportation regulations. So that is the federal law that makes schools have a mandatory drug testing program in place, which has been a longstanding policy offered through the templates. But I'll dig in and explain to you the revisions that I made. I'll monitor questions and take questions at the end, so feel free to hold your questions or type them, and then I will see if I can maybe get my chat out. I had it out before. Okay, so I can see questions as they filter, and I can definitely monitor that. Policy DEAA, that is the drug and alcohol, it's titled Drug and Alcohol Free Workplace. That is an accurate title, but also I would say in practice, it means drug and alcohol free workplace for employees and learning environment for students and staff and anybody that's on school property or participating in school activities. So the federal law, the first two laws in particular that I went over, those are going to lay out your minimum requirements that must be followed to establish drug and alcohol-free workplace and learning environments for students and staff. That's your minimum requirement. But to further the goal, I really do recommend comprehensive policy and practices that includes prohibitions applicable to everyone accessing school property and activities. Employees, students, parents, independent contractors, vendors, visitors, members of the public. I think in practice, the feedback I've received over the course of several years and observations would include that in practice, being under the influence of substances while on school property or in school activities, distribution, use of illicit drugs, it's not typically tolerated. But previously, I would sometimes get questions as to why policy wouldn't address outsiders or people other than employees or students. And so we included some options this last round to kind of have a blanket policy that schools are drug and alcohol free areas, which sounds like common sense, but it's probably pretty important to have in written policy when you have visitors on your property. Effective drug and alcohol abuse prevention programs, of course, are always going to include that written policy with the clear compliance statements, the purpose and the rationale for the policy, and the expectations for compliance, penalties for your employees, for instance, and employee assistance programs. But, making sure that you have all of the awareness and educational opportunities and drug testing components really does require a comprehensive approach. So I will dig in to just some of the revisions that went into place. What you see when we roll out policies, of course, is going to be, hold on, just making sure I can see this still, is going to be the final product, right? And so what I have pulled up is an option for you to see the track changes. So this is these are screenshots directly from the documents that I was working off of when I was tracking changes. So some of the changes are Really small, but I thought important just to make sure we had accuracy. And one thing I've been trying to do in policy that I personally, from a practitioner's perspective, believe is important is allowing you specific legal references so you understand the law supporting policy when it's a required policy. I get a lot of questions about policies, this language is in the policy, why? Or what law supports that policy? It's no secret. So I really want to make sure that the laws supporting policy are there for you so you know where to find it yourself. So I updated and made sure to cross-reference and ensure accuracy of the legal citations to state and federal law. So I went through and made sure those were in there. So not a big change, but just some accuracy parts. You will see the reasonable suspicion bracketed language in the DEAA taken out because I moved that entirely over to the testing program. I was receiving feedback over the years that this was a little confusing, or in practice, those having to deal with drug testing and having to approach employees didn't love having to jump back and forth between two policies, the testing program and the drug and alcohol-free workplace. And previously, the reasonable suspicion for the non-covered, non-safety sensitive positions, the testing was only in this policy, but as a practical matter, as a school, your testing occurs through one program. It just does. And so it's not that I'm recommending that reasonable suspicion testing be removed from your processes. It's simply that I moved it to the other policy where testing is unique to that policy. And then we leave this policy as the actual statement and compliance pieces with the first two laws that require a drug-free workplace and learning environment. So that's why that's not taken out, but just moved. Federal law requires a purpose statement. And so this purpose statement, I put in there to match the exact language of what federal law requires. And to promote this goal, I say, the district is a drug and alcohol-free workplace, and employees are required to report to work unimpaired in any way by the use of alcohol or drugs. So you will just see some specific language that mirrors federal law a bit better. I also included some requirements about informing. I received feedback and encountered a number of situations in which employees are on maybe even lawful drugs or prescribed drugs, but those drugs can impair their judgment, even if lawful use. And so I'll talk about this a little bit more in another portion of the policy, but I did include language. Before, it just said an employee must inform their immediate supervisor when the employee's ability to perform job duties is impaired. I just expanded it a bit and said must immediately inform, because I think that's pretty important. And when their job duties are impaired or infected in any way. I just wanted to broaden that because employers can absolutely require employees to keep them informed about anything that's going to affect or impair their job duties, especially in a school where safety of students and other staff is highly important. Schools obviously are unique workplaces because they are also learning environments. The other thing I did was include reference that this policy is very specific to employees, but we do have a separate student policy, and students must abide by district policy FFA. So that I wanted to make sure was clear in this policy, just for clarity. And in case, you always think of the audience that might be accessing this policy. It's not just those working in a school, but it could be community members, parents, and they need to understand that there is a applicable policy that is student specific as well. And then, as I referenced earlier, I also expanded the scope of the policy to apply to all school employees during all working hours on all school property and all school sponsored events and other times when they're representing or conducting school business. That a language of some sort was already in policy, but I wanted to make it very clear. And then the additional language I'm recommending that schools adopt is that the scope of the policy and the concept of a drug and alcohol-free workplace and learning environment may apply to all students, parents, contractors, vendors, visitors, anybody who's on your property or at a school-sponsored activity or event. That just allows administrators to address conduct or ask visitors to leave within, their observation or discretion when that is something that needs to be done in the interest of maintaining a drug and alcohol-free workplace learning environment. So I received, again, a lot of feedback about maybe a gap in the policy, or can't we also make sure that this concept and policy applies to people beyond employees? Yes, remember the minimum federal requirements require drug and alcohol-free workplace for employees. This is policy. You can also expand your policy to include to anybody who's on your property. That is absolutely true. And then I talked about removing reasonable suspicion testing from this policy and just placing it exclusively under one uniform drug and alcohol testing program. That way, those who are actually working in your schools who have to do the testing or understand when testing is required or pull up that policy, they're working in one policy when it comes to testing. So there are statements in here you will see where I have a drug and alcohol testing section, so that if you are reading this main policy, you understand that testing may be required, and it is certainly required for the covered and safety sensitive positions. And then there's optional language if you want to also, as a school district, allow for reasonable suspicion testing of any employee. Basically meaning, just as the word means, if you reasonably suspect somebody is under the influence or using illicit drugs or alcohol on school property or at a school event, then you have that reasonable suspicion to test. That is allowed, but because it's not required, it's bracketed. So then I include that reference to, again, the policy that applies to students. And then I include the reference to the actual drug testing policy, which is DBBA. So then anyone accessing this policy would know you would have to jump over to the testing policy to understand the testing procedures. I also made clarifications. The drugs are expressly prohibited unless such use is lawful. And this is where I'll revisit the concept of those lawful drugs. And one, at the instruction of a treating medical provider, and the provider has advised that such use will not affect employees' ability to perform duties. And employee has engaged in that interactive process with the school district in accordance with Americans with Disabilities Act. The threshold to prove disability under the ADA is very low. So if you have an employee under the influence of a certain class of drug off school premises on their own time, but they have to or they could be required to use on school premises, or they're certainly coming to work under the influence of that prescription drug, it is just important that the schools have worked with that employee so that they understand, the employer understands what's going on, can have assurance that that use will not affect the employee's ability and judgment and the health and safety of students and others that they're working with. And when I say interactive process, that is just that back and forth conversation between employer and employee to make sure that there is a understanding, a plan in place, an accommodation. Because basically, if you're allowing an employee who is under the use of a certain prescription type drug to come to work under the influence, that is an accommodation. So I included language in compliance with additional intersecting laws that do open the door and allow an employer to engage in that process to make sure that the use is safe and not affecting the employee's ability to perform the essential functions of their job. And this is just policy language with a broad stroke. If this situation actually occurred and an employer had questions, was concerned, wasn't quite sure what they should do with the information they've received, by all means, you should most certainly reach out to legal counsel for your school district and work through that individual situation. based on the facts and circumstances. But at a policy level, this is how it's at a broad stroke laid out. Okay. I also get a lot of questions about arrests, charges, that sort of thing. As a previously policy read as a condition of employment, each employee shall agree to abide by the policy, and then the superintendent, in accordance with applicable law, shall notify appropriate federal and or state agencies after receiving any notice of a conviction for a violation occurring in the workplace. That is the minimum requirement under federal law, that if unlawful use, distribution, etc., is occurring in your workplace, federal law requires appropriate reporting. In policy, employers can also require employees to immediately, or as soon as practical, inform their supervisor or superintendent when the employee has been arrested, charged, adjudicated, or convicted of any drug or alcohol-related crime or offense. What I see most often happen in practice in these unfortunate situations when an employee is arrested is that the employer finds out alongside the public. Maybe their mugshot starts circulating on social media, or maybe the superintendent starts receiving complaints, or maybe you see your own employee on the news. That is often what happens. And there was just a gap in policy a bit, from my observation, that did not require employees previously to report when they've been arrested. There's a lot of reasons you might need that report. One, has something been flagged in the workplace you need to be aware of? Two, is this employee going to now need to miss work? They've got something very serious going on in their personal life. Three, is this conduct unbecoming their position working in your school? There's a lot of reasons why it's entirely reasonable for a school to be informed about this information beyond just seeing it with the rest of the public. And as a practical matter, members of the community often complain when an employee has been arrested for, a DUI or drug possession or something, right? And so your administration gets these complaints and they need to know to deal with it. So I did include some language that you're free to adopt that would require employees to immediately or as soon as reasonably practical inform their supervisor and superintendent of their arrest. And I'm not saying they're guilty, it's an arrest or a charge. But there are a lot of reasons why clear communication channels should occur between employee and administration. And that probably happens in practice anyway, if you have an employee arrested, charged, whatever. But clarifying it in policy that it's actually an expectation of employment for the employee to maintain in communication with their supervisor when these situations happen is important. Again, school workplaces are not like other workplaces. They're in the public eye. You're dealing with young, mostly minor students, and it's important that in these situations, employees are maintaining in close contact with administration and communicating as to what's happening with this charge or arrest. So that is why you see that change in policy in that area. I also made some small clarifications about violations of the policy that could result in paid or unpaid leave or suspension. Before it read, violations of this policy may result in the following, and that bracketed language is from previous policy, completely appropriate. You could certainly require an employee to participate in an employee assistance program or rehabilitation program. Chemical dependency leave shall be granted in accordance with your leave policies. That is unchanged. Previously, though, it read unpaid leave or suspension. But of course, for your certified employees, only the school board can place a certified employee on an unpaid suspension in the event they're contemplating discharge. And that there's a lot of situations where that might not be occurring, but the employee still needs to be put on leave. So I just included paid or unpaid leave or suspension as allowed under the law. It would be different for your at-will classified employees versus your certified employees. So this language just provides the appropriate accuracy for what is actually allowed under the law. And then I made some changes again with notification to proper law enforcement authorities as required or allowed under the law. There could be times, again, right, that federal law requires reporting. But with some of those changes in policy that require, for example, employees to notify a school if they've been arrested off school property, right? That wouldn't be a situation where you would separately report to law enforcement. Law enforcement already knows. So notification to proper law enforcement authorities, obviously, when something unlawful has happened on school grounds would be appropriate. But there are certain situations where you wouldn't report because something might have happened off property, but you have it now in policy to report internally, if that makes sense. So I just added that bracket for accuracy purposes. And then I added notification to other reporting agencies as required or allowed under the law. I get a lot of questions if an employee, for example, has been adjudicated in a drug-related offense outside of, again, school property, or like a DUI or something like that. And I often get the question, does this have to be reported to ESPB? I always counsel those on an individual basis based on the facts of the situation and circumstances, but there's a difference between mandatory reporting and optional reporting. So I think it's important to have the option where, and clear notice to employees in policy that there could be other reporting agencies that have to be notified. But then again, only as required or allowed under the law. So added that. And that is primarily, those are the track changes. I walked you through all my track changes for DEAA. Then the second policy I tackled was the DBBA, the drug and alcohol testing program for employees. I'm just trying to make sure I keep monitoring your chats. Okay. Like the drug-free workplace that's required to be maintained, federal law also has requirements related to testing. So federal law requires employers, as I mentioned before, to establish a drug and alcohol testing program for your covered employees, meaning those covered under certain laws, and those positions, and then the safety sensitive positions. That is an actual term used under the law. So covered employee positions is going to mean those employees and positions that are subject to the Drug-Free Workplace Act or the Omnibus Transportation Employee Testing Act. And likewise, safety sensitive positions are those jobs where a momentary lapse in the discharge of duties poses a safety threat with potentially severe consequences. So those who hold those commercial driver's licenses or those who are driving students, that is always a very clear safety sensitive position. The OTETA and U.S. Department of Transportation regulations work hand in hand for your CDL drivers. So those two laws set the minimal federal standards for the required drug and alcohol testing, including those working in school transportation with the CDLs. I've already alluded when we were walking through the DEAA that other employees testing is not required, like it is for the safety sensitive positions, but the Drug-Free Workplace Act allows reasonable suspicion or special need testing for other employees. So those would be your non-covered, non-safety sensitive positions, and essentially meaning any other class of employee that's not covered under legally mandated or allowable federal drug and alcohol testing requirements, but it will include a class of employee who may be subject to school policy for testing upon reasonable suspicion. And reasonable suspicion, as we discussed earlier, means just that suspicion that an employee is using, distributing, or under the influence of drug or alcohol at work. And we have supplemental policies that help schools walk through how do you get to reasonable suspicion and kind of a checklist. So we also have those supports. So again, you can see my tracked changes where I went through again and added just some updated legal citations and made sure to include the citation for a school vehicle driver, which is unique under our state law. I included a definition for the non-covered and non-safety sensitive positions because, again, remember previously, any reasonable suspicion testing for other employees that are non-safety sensitive was in the other policies, and I brought it all under one testing program. So I thought it was important to make sure that we have an actual definition for non-covered, non-safety sensitive positions. And of course, there's cross references back to the district policy DEAA, because that's always the philosophy policy, your stance, your prohibition policy. And then again, this policy's purpose is always going to be testing focused. I also did some updates, some smaller updates to the notice of medication use section, which requires employees to notify the school anytime they're using medication prescribed by a provider that could adversely affect their performance of any work duties. And this was already in policy. I just bolstered it a little bit. For instance, the term physician is used, but a lot of employees don't see actual physicians. They might see a physician's assistant. They might see a nurse practitioner. So the more updated term is typically treating medical provider. And I always include the term treating because that means the provider that you did not just stop in to see. Treating medical provider means the person whose care you've established and you're under. So it's just a term that's often used in the medical world / employment law world, and it's treating medical provider rather than physician. And then I included that could adversely affect their performance of any work duties, including safety sensitive position duties. Before, it said, that employees had to notify their employer only if they were under the use of a medication that could adversely affect their safety sensitive duties. So essentially you could have a teacher who also drives bus, but if their medication doesn't affect the driving duties, then they're not going to, maybe report. But there could be a reason if it's affecting their teaching duties that you're going to need to know as an employer. That is the purpose of this language, to make sure those communication channels stay open so you can keep your workplaces safe and make sure that employees are able to perform all of their work duties in a safe and healthy manner. And then participation in the drug and alcohol testing program required. Employees serving in positions that are covered and safety sensitive positions under policy are required to participate. And then this is where you get your bracketed language. For employees serving in the non-covered and non-safety sensitive positions are subject to reasonable suspicion. Again, that is bracketed and optional language because the law does not require reasonable suspicion testing for other employees. But so it's bracketed in case schools want to implement it. In case you have a teacher that shows up and appears to be under the influence of alcohol, or a para, or a janitor, or a cook, or anybody else that's not in a safety sensitive position, is not driving a school bus, but they're drunk on the job. If you want to do a reasonable suspicion testing based on that reasonable observation, that's what this bracketed language, if you were implementing it in policy and accepting it, would allow. I also added some clarification of the circumstances and the scope of the school's drug testing and alcohol testing program, which would include, again, the mandatory policy language for the covered and safety sensitive positions, and then again, that optional language. So you'll see that optional bracketed language throughout this policy again, because I moved reasonable suspicion testing into this policy along with all types of testing for just ease of understanding and using a policy. This is the part of the policy that was most probably of both policies that was most heavily revised. In private practice, I did a lot of drug and alcohol-free workplace policies in compliance with federal law, and have worked with a lot of policies. So I brought, some of that knowledge over, and then it's not like that the previous policy didn't have each of these categories, because it did. I just organized it in a way that's a little more custom to what a lot of other federally compliant policies do. And I just think it's a little easier to follow. So if you have specific questions that you've seen in this policy change, because it maybe looks so different than what it used to, please feel free to reach out to me. I'm happy to talk about any individual change. It's too much to go over when it's so redlined, but you can see just even the way I organized it, where I broke out the pre-employment testing, which again, that's only for covered and safety sensitive positions, promotions, transfers, random safety sensitive positions. And then that reasonable suspicion that could apply to all employees, or again, you can just maintain it to be covered and safety sensitive positions only. And you can see how I have that all organized and laid out. I wanted to pull out one little area from what I just showed you on the previous screen, and that's the optional language for follow-up testing when an employee has been requested or required by the school to go to a rehabilitation program because of a confirmed test result as confirmed under agreement between the parties. This is actually another one of those intersections with the Americans with Disabilities Act. It's follow-up testing for either all employees or just covered and safety sensitive positions only. But the district can require testing as part of a follow-up program to treatment for drug or alcohol abuse when an employee has been requested or required by the district to go to the rehab program because of a confirmed test result. And the frequency of that testing in terms of such testing shall be confirmed under agreement between the district and employee. These are often called in the employment law world last chance agreements. And it essentially means you've had an employee who's tested positive during work duties on school property or at a school event, and you're giving them one last chance through employee assistance or rehabilitation to get the help they need. However, when they come back, they may be subject to testing, and they might be subject to testing not just once, but in accordance with what is agreed upon between the parties. And that is absolutely allowed under the ADA. And that's typically called last chance agreements. So if you're ever in that type of situation and you implement this bracketed language into your policy, that would be a specific time probably to reach out to counsel as you're working through that individual situation to make sure that you're doing it correctly and that you get the guidance you need as to what's allowed under federal law. But I wanted to pull that out because it's another unique intersection with other federal laws. There's also that optional language, and I think it was in another portion of the policy too, for first offense participation in rehabilitation, substance abuse treatment prior to discipline, unless the employee refuses to participate or fails to successfully complete the counseling or rehabilitation program. Not required, but again, that is optional language that your policy committee, board, administration, whomever works on your policies would really want to discuss and think about what the district is willing to offer to an employee. So sorry, I'm trying to make sure my chat stays open. And then the testing procedures themselves, I pulled out all of the track changes in that area. Clarification that a failure to consent to testing or unacceptable behavior during testing may result in discipline, termination, or rescission of a job offer. And there was clarification to the events that qualifies a refusal to undergo testing, which at a minimum will prevent an employee from performing their covered and safety sensitive duties, and that could result in a refusal of employment, discipline, discharge, whatever matrix you have in place for discipline. But you'll just see, again, this was already in policy. I just pulled it out to bullet it and make it a little easier to read. But you can see what refusal to submit looks like. Failure to appear for a test, declining a test, not providing an adequate sample, failing to immediately report to the collection site as instructed, tampering with the specimen, interfering with the collection procedure, not making yourselves readily available for testing following an accident, that sort of thing. That is all allowed under federal law. So I have a bulleted out for ease to read a little better. And then there's a number of templates that have been in place for many years at the NDSBA to assist with recording observable behavior, steps to performing a reasonable suspicion test, drug and alcohol testing consent forms, just really great exhibits that accompany the policies have been in place. But what you'll notice, one thing I changed since, again, I moved I moved that reasonable suspicion testing into your main testing program. It doesn't make sense to leave them as the DEAA exhibits. They are more properly DBBA testing exhibits. So that's the change for that. There's also a DBBE exhibit that was previously called drug and alcohol testing for employees. But when I reviewed it, it was very clearly actually a drug and alcohol testing for drivers policy that is specific to Department of Transportation regulations and what they require as a checklist for driver testing. So there wasn't a lot of changes to it, but I just made it more accurate that it's a testing checklist for your drivers, your school drivers. So you can see that there are obviously the additional resources. There's an administrative regulation, a few exhibits to assist when you're working through these testing issues. And those are the changes. I thought it would be helpful, again, just to show you, because there were so many changes, to take some time in this webinar just to show you what those changes looked like in their tracked version. Sometimes when you get the final form, it's hard to know exactly what was changed. Wasn't that in there before? And so again, a lot of it was in there before. I maybe just moved it around or I added some language. And I just wanted you to have an opportunity to jump on and see exactly where the changes were tracked and how they operated and why I made those changes. If you have questions, I didn't see anything filter into the webinar chat. If you do have questions, you can certainly type them, or well, I think most of you know how to get a hold of me, which is totally fine. My email's on the website and our phone number is available as well. If you do have questions about the policy or you need specific legal counsel, you can reach out to myself if I'm your legal counsel, or separate counsel if you use. And, you know, we're happy to assist. Otherwise, Sheila, I think that's all I have. Again, reach out when you have questions, and just let me know whenever I can help, especially with so many changes that went into these policies.
Thank you, Chris-Ann.
Yep. Thanks, everyone.